All right, subpart D, handling, testing, and result of the record retention confidentially. Retention record with the general requirement each employer shall maintain the record of the alcohol misuse control substance prevention program provided. This section record shall maintain the section is secure the location of the controlled action for the period of retention. The employer shall maintain the record for the accordance with the following schedule. 5 years. The following record shall be maintained a minimum of 5 years. Record of driver alcohol testing with the alcohol concentration 0.02 greater. Record of the driver to verify with the positive of the controlled substance test and resolve the documentation. Refusal to take required alcohol to controlled substance test. Driver evaluation referrals, calibration documentation, record related with the administrative of the alcohol controlled substance testing program, including the records of all of the driver's violation. A copy of each of the annual calendar review summary with the requirement 382-403. 2 years records related with the alcohol controlled substance collection process exempt calibration of the evidential breathing testing device shall be maintained a minimum of 2 years. 1 year records of the records of negatively canceled controlled substance testing result of the defined in Title 4, Part 40 title of this part. Alcohol test result of the concentration less than 0.02 shall be maintained at a minimum of 1 year. Identified period record related to educational training, breathing, alcohol, technician screen testing, technicians, supervisors, drivers maintained by the employer with the individual perform the function required by the training of the 2 year after ceasing to perform these functions. Type of the record, the following specific type of the record shall maintain the documents generated. Documents are made have to be prepared with the requirement of this part of the records required to prepare must be obtained. Records related to the collection process, collection logbooks if used, documented documents relating to the random selection process, calibration documentation, evidential breathe breath testing, documentation, breath of alcohol, technician training, documents generated with the connections decision, administrative reasonable suspicion, alcohol control testing, documents generated with the connection with the decision, post-accident testing, documents verifying existing medical explanation, inability to drive to provide adequate breath to provide urine specimen of the testing, a copy of each of the calendar summary with the required in the statute 382-403, record related with the driver test for the employer's copy of the alcohol test form, including the result of the test, employer's copy of the controlled substance test chain with the custody of the control form. Alright, documents sent by the MRO of the employer include those required in Part 40. So Part G with the title of the documents related with the refusal aim of the driver to submit with the alcohol control substance test required with this part. Documents presented with the driver to dispute with the result of the alcohol control substance test and administer with the end of this part. Documents generated with the connection verification prior employee with the alcohol control substance result of the employer must obtain with the connection exemption with the 382-301 must obtain with the required 382-413 records retaining all other violations of this part. Records related to evaluations. Records pertaining to determination of substance abuse professional concerning the driver's need for the assistance. Records concerning the driver's compliance with the recommendation of substance abuse professional. Records related to educational and training. Materials, alcohol, misuse with controlled substance and awareness, including copy of the employer's policy, alcohol, misuse with the controlled substance, use with the documentation of compliance with requirements of 382-601, include with the driver's sign and receipt of the educational materials, document training, travel provided, supervised for the purpose of the qualifying supervisor to make the determination concerning the need of the alcohol controlled substance, testing based on reasonable suspicion, documentation and training with breath alcohol technicians required in statute 40-213G of the title, certification of that any of the training conducted within this part comply with the requirements of such training, administrative records related with the alcohol controlled testing, substance testing. Alright, agreements with the collection site with its facility, laboratory, breath alcohol, technician, screen testing, technician, medical review, office consorters, third-party service providers, names and position official with their role, employers, alcohol control substance testing program, semi-annual laboratory statistical summaries of your analysis required in statute 40-111. A of the sales employers alcohol with the controlled substance testing policy procedure. Location records. All records retain parts of the maintainment requirement 3090 29 of the substance of this subchapter shall be made available to the inspection employer principal of the place of business 2 business days after the requests have been made. Authorized representative of the Federal Motor Carrier Safety Administration. Office management, budget, control number, information of the collection requirement to have reviewed the Office Management Budget pursuant to the Paperwork Reduction Act, having been assigned to Office Management Budget Control number 21260012. Information collected requirements of the part of the found in 382, 105, 113, 301, 303, 305, 307, 382, 401, 403, 405, 409, 411, 601, and 603. Alright, 382, 403, reporting result of the management information system. An employer shall prepare with a maintained summary of the result of the alcohol controlled substance testing program of the form of the during the previous calendar year with the request of the Secretary of Transportation, agency, state, local official with the regulatory authority of the employer, and any driver of the employer with the notified during the month of the January request of the Federal Motor Carrier Safety Administrator of the report of the employer's annual calendar year summary information. Employer shall prepare the submit the report of the Federal Motor Carrier Safety Administration March 15th of the year. Employer shall make sure of the annual summary of the report accurate receive the the March 15th location of the Federal Motor Carrier Safety Administration specified with its request. Employer must use the Management Information System form and instructions required in Title 49 CFR Part 40. The employer may also use the electronic version of the MIS for the provided by the Department of Transportation Administrator. The design means other than hard copy, the MIS form submission for information electronic furnished form visit the website. The report submitted with the Federal Motor Carriers Administration mail electronic transmission information requested type should be typed and accepted by the signature certifying employer. The employer shall ensure the accuracy timeline each reporting submitted to the employer with a consortment. If you have covered the employer with a performed multiple agency function with a commercial count with the employee only with the MIS report on the agency under which she is randomly tested. Normally will with the agency under when the employee performs more than 50% of his or her duties. Employers may have the explain the testing data with the employees in the event with the agency inspection or audit. A service agent may prepare the MIS report on the behalf of the employer. However, the company official must certify the accuracy, completeness of the MIS report, no matter who prepares it. Alright, 382-405, access to facilities and records, except the required by the law expressly authorized required by the section. No employer shall release the driver information contained with the records required by the maintenance. 382-401, drivers until upon written requested to obtain the copy of the name of the record pertaining to the driver's use of the alcohol control substance, including the name of the records pertaining to his or her alcohol controlled substance test. The employer shall promptly provide with the records required requested by the driver. The action for the driver of the records should not be contingent upon payment of the records other than specifically requested. Each employer shall permit the action for the facility under the complying with the requirements of the Secretary of Transportation agency, any state, local official, regulatory authority over the employer, any of its drivers. Each employer, each service who maintains the records of the employer making available a copy of the rest result of the alcohol and controlled substance testing control conduct with the employer under this part any of the information pertaining to the employer's alcohol misuse and controlled substance use, the prevention program requests the Secretary of Transportation, any agency, any state, local official with the regulatory authority over the employer of the intending driver. The request of the National Transportation Safety Board as part of the crash investigation. Employers must disclose information related to the employer's administration of the post-accidental alcohol controlled substance test administrative file with the crash under investigation. Federal Motor Carrier Safety Administration provides the information clearinghouse for the concerning the drivers involved with the crash under the investigation. Records shall be made available to subsequent employers upon receipt of the written request of the driver. The disclosure of subsequent employers and permitted only as expressly authorized by the terms of the driver's request. An employer may disclose information required for the maintainment under this part pertaining to the driver, the decision maker of the lawsuit, the grievance administrative proceeding initiated by on behalf of the individual arising with a positive drug test, alcohol test refusal, including but not limited to all alterated substituted tests of this part, included but not limited to work compensation, unemployment compensation, other proceeding relating to benefits sought by the driver. Additional employer may disclose the information criminal civil actions according to the Title 4 Statute 4323A2. Employer shall release information regarding the driver of the record, directed specific written consent with the driver's authorization, release information, identified person release such information, information by a person receiving the information permitted only in accordance with the terms of the employee's specific written consent is outlined in Statute 4321B of this title. 382-407, the medical review officer of the notification of the employer. Medical review officer shall report the review result of the controlled substance test in his employer in accordance with the requirements of Part 40, Subpart G of the title. 382-409, medical review officer of the consortium, third-party administrator of the record retention of the controlled substance. Medical review officer of the third-party administrator shall maintain the dated records of the notification, identify the individual minimum of 5 years, verified positive of the controlled substance test result. Medical review officer of the third-party administrator shall maintain all data records of notification identified by the individual minimum of 1 year negative to cancel with the controlled substance testing results. No person must obtain the individual control testing result of the obtained with the medical review officer or consortment of the third-party administrator, or no MRO or consortment of third-party officer, third-party administrator may release the individual controlled substance test result of any driver to any person without first obtaining specific written authorization from a tested driver. Nothing in the paragraph C of the part of the MRO of the consortment of test third-party administrator for releasing the employer clearinghouse over the Secretary of Transportation, any agency and state local official with the regulatory authority over the controlled substance alcohol testing program under this part information delineated in Part 40 of Subpart G of the title. 382.411 employer notification. Employer shall notify the driver of the result of the pre-employment and controlled substance test conducted within this part. Driver will recover the test result of the 60 calendar day to be notified of the disposition of the employment application. Employer shall notify the driver of the result of the random reasonable suspicion post accident test for controlled substance conducted as part of the test and the result of the verified positive. The employer shall also inform the driver of the controlled substance or substance when verified as positive. Designated employer representative shall make the reasonable reference of the contact request information address to the driver to submit the specimen of the employer's program, regardless of the driver's employment status, to contact and discuss the result of the controlled substance test with a medical review officer who has been unable to contact the driver. The designated employer representative shall immediately notify the medical review officer. Driver has been notified. Contact the medical review officer within 72 hours. All right, 382.413 inquires alcohol controlled substance information previous employers. Employers must request controlled substance information previous employer in accordance with requirements 4025. Anti-acceptable employers must request the information that regulated employers employed with the driver for previously 3 years. Scope of the information requested must date back 3 years. As of January 6, 2023, employers must use the Drug Alcohol Clearinghouse in accordance with 382.701A to comply with the requirements of 4025. The title respect with the Federal Motor Carrier Safety Administration. Regulated employers exception where the employee is not subject to follow-up testing, not successfully completed at all follow-up tests. Employers must request the employee's follow-up testing plan directly with the previous employer in accordance with the statute 4025B5. If the applicant was subject to the alcohol controlled substance testing program under this requirement, the agency other than the Federal Motor Carrier Administration, employer must request the alcohol controlled substance information required under this section statute 4025 titled directly with the employers regulated by agency other than Federal Motor Carrier Safety Administration. All right, 382.415 notification of employers controlled substance alcohol testing program violation. Each person holding a commercial driver's license subject to the controlled substance alcohol testing requirements of part of the violated alcohol controlled substance prohibition under Part 40 of the title of this part without complying with the requirements of this part. Title 40, Subpart O, must notify the writing all current employees of violation. The driver that is not required to provide notification to the employer that the administrative test documentation circumstances that gave the rise to the violation notification must be made before the end of the business day of the following day, but the employee received the notice of the violation prior to performing the safety-sensitive function, whichever comes first. Subpart E, consequences for drivers engaging in substance use-related conduct.